I want to withdraw. I have an instruction to withdraw item number 1, my lord.
Item 1,
Yes, Dasiram Deka.
simple withdrawal.
Simple withdraw.
Mr. R.P. Sharma, then senior counsel.
Are lordship may keep liberty.
Request for withdrawal of district petition with liberty to file afresh. Who appears for secondary?
I am for the secondary.
Mr. U. Sharma, then standing counsel appears for the secondary petition. This petition is dismissed on withdrawal. With liberty, that's right.
My lord, this matter was directed to be listed in the month of February of this year, man. It's not being listed, my lord. So may I pray in the next week any date, my lord?
16.
Lordship. Diplomat.
May it please the lordship. Lordship, may I pray for listing of a matter for motion, lordship? Can it be tomorrow? There is some legal urgency, lordship.
What urgency is there?
In the next week, lordship, the petitioner has a final year examination in MBBS, lordship. But against the rules, lordship, the university authority, after accepting the application for examination, they have asked not to appear in the examination, lordship. Otherwise, the matter is covered by several order of this honorable court, lordship.
When is the exam starting?
From 17th, lordship.
Then we'll have it on Monday. Not necessarily tomorrow.
Obliged, lordship.
In item number 6, my lord, parted matter.
Yes.
An additional affidavit was filed in terms of the order, my lord, on 4/5, my lord. May I place that may be brought on record, my lord?
May I please, Dr.
Obliged.
Prasad? I recommend item number 19, my lord. The matter may be adjourned for a week, my lord. Engage counsel M. H. already out of session.
Item?
19, my lord.
Okay, on request made on behalf of Mr. M. H. Chaudhary, Learned Counsel for the petition. List up to 1 week.
My lord.
My lord, I would to mention item number 21
Yes,
on behalf of Mr. Slodip Dev, my lord, for the petitioner, my lord. I have taken consent from the other side, my lord.
oh,
My lord, matter will be approved for that, my lord. It's out of session, my lord.
pass over for the day. On request made on behalf of Mr. S. D, Learned Counsel for the petition. List up to 1 week.
My lord.
May it please your lordship. I beg to pray before agenda matter of item number 17, lordship. I have already taken the consent from the other side, lordship.
Item
17, lordship.
17 is with 18.
18 all 18 also same, lordship. But there is an interim order in item number 18 that may be extended, lordship.
No, you are appearing on behalf of whom?
SK Das, lordship.
S.K. Das. But S.K. Das is not in item 18.
17, lordship.
Okay, on request made on behalf of Mr. S.K. Das, Learned Counsel for the petitioner. In WBC 4151 of 2007. This matters when?
As if in
Up to 1 week.
lordship, I beg to before another listing to matter, lord.
There is an interim order in item 18.
18 in 18, lordship.
Interim order passed in WBC 2158 of 2024 to consider. Yes.
Lordship, I beg to pay before listing another 2 matter, lordship, in admission, lordship.
20 May.
Diplomat.
May it please, sir. I beg to mention for listing matter, any date next week, minute.
20.
Obliged.
May you please, your lordship, I beg to mention for item number 16.
Yes.
Appearing on behalf of Mr. R. Sharma, the conducting counsel is out of station. Maybe after 1 week.
Have you taken the consent from the other party?
Yes, lordship.
How about the petitioner in item 15? Have you informed him?
Uh,
Item 15 is analogous with item 16, isn't it?
Maybe item 15 also.
Huh?
Item 15 also maybe.
Automatically, if 16 goes, 15 will go. So have you taken consent from 15?
Lordship,
No.
I am for 15.
Yes.
With the consent of the other party, let it be taken after a week.
Okay, your R. Sharma.
R. Sharma is item number 16.
Okay, on request made on behalf of Mr. R. Sharma. Learned Counsel for the petitioner in WBC 7792 of 2019. When do you want?
Maybe after 1 week.
Please, after 1 week.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 20.
My lord, in this case, I have to submit something, my lord. As per order dated 29/2/2024, the honorable, this honorable court directed the parties to appraise the status of the civil appeal pending before the honorable Supreme Court. So, my lord, in this case, we have obtained the status of this honorable Supreme Court, but the honorable court has used the matter on 30th July 2024 for hearing, my lord. So if it is adjourned for 1 week, my lord, no fruitful result will come out. So after decision of the honorable Supreme Court, the matter may be listed, my lord. 30th July, the matter is fixed for hearing. So this is the one civil appeal which is for the appointment of the arbitrator from the railway panel. But it is applicable or not, it is under the challenge before the honorable Supreme Court, and the honorable Supreme Court heard this matter, and proceeding shall be listed on 30th July 2024. Para 2 of the order, my lord. Right, order dated 16/4/2024.
So you want on.
After 30th July, my lord, after decision of the honorable Supreme Court. Because this matter is pending with Supreme
Your
Court.
good name, please.
My lord,
Your good name.
you Chakraborty, Mrs. You Chakraborty. But I am the special senior railway counsel, my lord.
Then on your behalf, I'll list it.
Yes, my lord.
Okay. On request made by MS U Chakraborty. Learned Standing Counsel,
Special senior railway counsel.
Special Senior Railway Counsel. List this matters. List this matter again on. It's fixed on July 30, isn't it?
Yes, my lord.
We'll have it on 5th of August. 5th August.
August, yes, my lord.
Okay.
Obliged, your lordship.
Much obliged, lordship. May I please your lordship? I beg to mention item number 12, your lordship. The conducting counsel have some personal difficulties. As such, kindly adjourn this matter for 2 weeks, and I have taken the consent from the other side, your lordship.
Who's the conducting counsel?
Miss P. Agarwal.
Okay, on request made on behalf of MS P. Agarwal and Counsel for Petition. List the matter. When do you want?
After 2 weeks, your
After
lordship.
2 weeks.
Much obliged, sir.
Yes.
May it please your lordship, I beg to mention for listing for motion. Lordship, we have filed a new writ petition, filing number 5276/2.
It's a new filing.
Yes, lordship.
When do you want?
On Monday, lordship.
Why the urgency? What is the urgency involved?
Lordship, give us any date.
15th.
Motion, lordship.
Yeah, please, my lord. My lord, item number 17 and 18 are connected matters which have been mentioned, my lord. I am appearing for the item number 18. There is an interim, my lord, that may be. I'm deeply obliged.
I'm doing the order. Interim order.
I'm obliged.
Item 2 of daily list. Stay vacating executive. Two.
May I please your lordship?
Yes.
Your lordship, the respondent has filed the interlocutory application
Lordships,
for vacation of the order.
I ask for vacation of the interim order, Lordships. That is order was 21/8/2021.
Page.
It means only the one annexer at page number 9. Can
Of your IA.
I Lordships.
Where's the interim order?
Your lordship may very well peruse order dated 24/8/2021.
No. Where's the interim order?
Interim Main here not.
No, in your IA, you have to include that in your IA.
Lordships.
Have you annexed the interim order?
Lordships. Lordships, the main,
I'm not talking about the main writ petition, I'm talking about the IA.
Lordships.
Have you annexed the
Annexed,
interim order?
not annexed,
Why?
Lordships.
Why you have not
Lordships.
annexed?
Only the,
IA should be able to stand on its own
Okay.
without considering the writ appeal or the writ petition. Where's the interim order? Have you annexed it?
not annexed.
Why?
Lordship, only one certificate to annex.
I'm not talking about your certificate. I'm talking about the interim order. Have you annexed the interim order?
No, Lord.
How are you filing this type of writ applications?
Sorry, Lord.
There are some basics. Who is the interim order in the writ petition?
Lordships on the writ petition, there is 24/8/2021. First order.
Your Lordship, in this petition, Your Lordship, I'm the petitioner. He is the respondent, Your Lordship, who has filed the IA.
Yes.
Lordships, 11, para 11, Lordships. As it cannot be said with certainty as to in what manner the Act of 2017 would be applicable
Yes.
to the areas of BTC. And whether respondent number 6, being a teacher in Bodo language, would have any kind of preference over the other language teachers, we deem it appropriate to provide in the interim that the benefit of provincialization be not given to the respondent 6 Narad Brahma and the respondent 7 Louis Chandra Brahma until further order. As we are passing a restraint order in respect of both the respondents 6 and 7, we expect the respondent in the BTC to immediately file their affidavit before the next returnable date so as to enable the court to suitably modify the interim order in respect of the respondents who would otherwise be entitled to provincialization under the law. Here, as per their allegation that both are language teacher, actually not. Both are not language teacher.
In terms of para 11,
11.
writ petition has to be considered. Not the IA. In terms of this para 11,
Now,
the merits of the
whether-
merits of
whether-
the case will have to be
whether
decided.
BTC filed affidavit or not. If filed, then it may be perished also. And finally, it may be disposed of.
Nayak, you are paying for.
Finally, it may be disposed of.
Just filed on 11/12/2022.
It has been filed.
Based on the materials on record, may be disposed of the writ petition.
Yeah, we proceed, we are not taking up the IA, we'll proceed with the writ petition. Are you ready?
Yes, Your Lordship.
All parties are represented?
Yes, ma'am.
You have four?
I'm for the department, elementary department.
Your Lordship, Your Lordship may very well peruse order dated 6/2/2024. Your Lordship, the Honorable Court has directed
1 minute. 6/2.
2024. Your Lordship, there was a direction that the minutes of the District Scrutiny Committee be produced before the Honorable.
Yes, madam. I have received.
You have got the minutes?
Yes, ma'am.
Yes, proceed.
Yes, Your Lordship. Your Lordship, in this instant matter,
Your Lordship, everything came into light when the respondent number 6 and 7, they respectively filed their affidavit in opposition, wherein Your Lordship, the dias data from the year 2010-11 has been annexed in those affidavit in oppositions. Now, Your Lordship, as per the Act of 2017, Your Lordship, there is a duty which has been imposed upon the District Scrutiny Committee, the state level scrutiny committee, and the state government. Now, all these three committees, Your Lordship, they have been bestowed upon the responsibility as regards the institution which needs to be provincialized, the venture education. And those committees headed by the Deputy Commissioner, then Your Lordship, the director, and at the state government, the commissioner, they were bestowed the responsibility to verify the services of the teachers serving in those venture educational institutions. Now, Your Lordship, it is very difficult for any of the committee to ascertain the very services as regards who is teaching what. Your Lordship, as per Section 3(1)(11), 3 teachers have to be appointed in a venture educational institution. Now, in my case, Your Lordship, I submit in my writ petition that I have taught social science and English. Now, those two aspects have clearly come out from the dias data which the respondents have annexed in their affidavit in oppositions. From the year 2017 onwards till 2020, I have taught in social science as a primary subject, number 1, and number 2, I have taught English. Now, there are 2 subjects against those dias datas. Now, respondent 6, my main grievance is against respondent 6, who has taught Boro language and mathematics. Now, the headmaster has also taught Boro language and social science. Now, I have joined the said venture educational institution on the same date. Respondent 6 and 7 has also joined on the same date, but I joined at 10:15 a.m. Respondent number 6 had joined at 10:25 a.m. and respondent 7 had joined at 10:30 a.m. The Act also stipulates that there is no requirement for seniority criteria. The only requirement is that a teacher has to teach continuously from 2010-11 till 2017, 6 years of continuous service. Now, I have fulfilled all the required requirements. So, in brief, that is the very crux of the matter, Your Lordship. Now, everything have come into picture when the affidavit in oppositions filed by the respondent 6 and 7. Now, Your Lordship, the state respondents had also filed their affidavit in opposition, the director, wherein they had stated that I was not recommended. Now, on what basis I have not recommended? And I have also annexed in my affidavit in reply that the headmaster had admitted that I have been teaching continuously from the inception of my service into the school. Your Lordship, that is an error apparent on the face of the record. There is an abuse of the very administrative power which has been bestowed, and there has been a violation of Article 14. So I pray that respondent 6 services be set aside by issuing a writ in the nature of mandamus, because there has been a violation of Article 14. Your Lordship. So in that brief matter, this is the crux of the matter.
Yes, proceed. Proceed.
Yes, Your Lordship. Your Lordship, may I just take Your Lordship to Annexure A, Your Lordship, the very appointment letter. Now, the Bodofa Upendranath Brahmo ME School.
1 minute.
Yes, Your Lordship.
Annexure.
Annexure A, page number 21.
Yes.
Your Lordship, I was appointed by the school managing committee, my services being temporary in nature and may be terminated without any further information. Now, Your Lordship, in regards to that, the respondent 7 has alleged that I was absent, I was negligent in my duty, but there was no bar on them to terminate my service. The appointment letter says it so, Your Lordship. Now, Your Lordship, the very Annexure C, if Your Lordship peruse, and page number
No,
24.
no. Annexure A is on honorary basis only.
Yes, your lordship, honorary basis and terminable without any show cause notice or without any information, further information. Because the school, your lordship, at that point of time was a venture school. Now, your lordship may very well peruse Annexure C, page number 24. This is the type copy. Your lordship, there was an inspection which was being carried out by the block elementary education officer. And your lordship may very well peruse page number 25, wherein your lordship, I was placed at the second serial number and I was the second senior most assistant teacher. And your lordship, that has been an admitted position. Now, your lordship, subsequently, when the school was considered under the Repeal Act, as regards the Dias Data 2009-10 Annexure D, I was also again placed, page number 28, at your lordship may very well peruse the institution at page number 28, your lordship. Your lordship very well peruse serial number 46. Upendranath Brahma ME School, the last column, your lordship.
Yes.
I was also again placed at serial number 2, Dharani Chandra Brahma.
A column?
Yes, your lordship.
14 column.
Yes, I'll just verify that. Yes, your lordship. Second, lordship, Dharani Chandra Brahma, your lordship. So there was no issue. When that act got repealed and when 2017 act came into force, your lordship, then your lordship, the very issue of subject-wise teacher have come into play. That 3 subjects have to be appointed against by the government and the teachers who have taught in those educational institutions. Now, your lordship, the Dias Data is in my humble submission, is this record of the services, like who has taught what. I'll also take your lordship to the very affidavit in opposition.
Here in this data, you are shown as what?
Your lordship, assistant teacher, your lordship.
Oh.
But no subject wise has been given against my name. Subsequently, it comes into play when 2011-10 Dias Datas have been annexed, your lordship.
This is which year?
This is 2009 and 10, your lordship, the Dias Data. And the list was prepared for that institution to be provincialized. Now, your lordship may very well peruse Annexure G, your lordship. Annexure G, page number 34. The District Scrutiny Committee, your lordship.
Page 30.
For your lordship. Your lordship, I have typed the copy out, which is certified by me, your lordship.
Not legible.
It is not legible, but yeah, it is because of Xerox and all, your lordship. But they have admitted in their affidavit in opposition, your lordship. And it also reveals from the record that Dias Data also reveals the same stand which they have taken and which I have taken.
Is G or H?
Your lordship, it's G, your lordship. Page number 33, your lordship.
Yes.
It is the District Scrutiny Committee report. Your lordship.
Where is the original?
Your lordship, that is the copy which has been given to me, your lordship, and I have annexed, and a type copy has been also been produced before his own.
No, type. This is the type copy, isn't it? Page 32.
Yes, your lordship, type copy, and
in the original.
Yes, your lordship, original.
Page 34.
Yes, your lordship. But if your lordship wants to clarify, I'll just take your lordship to the Dias Data of the affidavit in opposition filed by the respondents, your lordship.
Which respondents?
Both of them have filed the same affidavit in opposition. I'll just take your lordship to respondent number 6. Your lordship, page, your lordship peruses.
Respondent 6.
Yes, your lordship. Annexure 9, annexure 11, your lordship.
Page.
Page 154, your lordship.
Yes.
Your lordship, if your lordship peruse serial number 2, the name of the petitioner appears Dharani Chandra Brahma, your lordship.
Yes.
Your lordship, under the column, your lordship, main subject taught, there are numericals, your lordship, numbers 8 and code, your lordship, actually 8 and 46.
Which column?
Yes, your lordship. Your lordship, 12 number column, 8 and 46.
Yes.
Yes, your lordship. If your 8 is the number 1 subject, main subject taught on top of it, your lordship, then your lordship, number 1 is the main subject 8. Now, if your lordship peruse down below, there are like categories about the either the qualifications and the subjects taught. Yes, your lordship. If your lordship peruse code number 8 is the social studies, your lordship.
Yes.
Now I have taught social studies 8 and 46 is the English. Those are the bone of contentions in my writ petition, your lordship. This is the dias data for the year 2016-17, your lordship. Now, if your lordship peruses annexure 12,
Yes.
your lordship, my name appears again at this second serial number, Dharani Chandra Brahma.
Where?
Your lordship, teacher's name.
Yes.
Lohit Chandra Brahma is the headmaster. He has taught Boro language as main subject taught 1. That is his primary subject.
Where is that?
He is the respondent 7. Your lordship may very well peruse main subject taught. On top of it is appointed subject 4.
Yes.
He has taught respondent 7 Boro language as his primary subject 1. I, on the other hand, Dharani Chandra Brahma has taught social studies 8. Respondent number 6 again has taught Boro language. Your lordship.
This is respondent?
Respondent 6, your lordship, against whom I have the grievance, your lordship. Narat Chandra Brahma.
Narat Chandra.
Yes, yes, your lordship.
Oh. Then?
Yes, your lordship. Now, again, main subject taught 2, which sometimes also being delegated with the discharge. Social studies respondent number 7, I English, and Narat Chandra Brahma mathematics, your lordship. Yes, your lordship. Now, again, your lordship may very well peruse annexure 13. The same situation has again evolved, and this is the dias data for the year 18-19.
The annexure 11 is 12?
Annexure 12 is the dias data for the year 17, your lordship, but for the year 17.
17, 18.
17, 18, yes, your lordship.
And annexure 13?
13 is dias data for the year 18-19.
Yes.
If your lordship peruse 5th number column, your lordship, Dharani Chandra Brahma, your lordship.
Yes.
I have taught main subject number 1, English, social science, which is 8.
Where's that?
8, your lordship.
Yes.
And 46 is English, your lordship. Your lordship, if I may clarify, when your lordship peruse Annexure 11, there the subjects have been divided, and the code for social science is subject, code number is 8, and English is 46. And here also, your lordship, the main subject taught by the respondent 7, the headmaster, is Boro language, and the respondent number 6, Narad Chandra Brahma, is Boro language. Your lordship.
Respondent 6 is Lohit Chandra.
No, your lordship, Narad Chandra.
31-3.
Yes, your lordship, Boro language, your lordship.
This is Boro.
Yes, your lordship.
And 3 is maths.
3 is maths, your lordship. Yes, your lordship. Now, your lordship, this is the whole situation, and I have come before this court challenging how come, your lordship, if qualifications be that, your lordship, both the respondent 6 and 7 have been provincialized as a tutor, because they also do not have the requisite qualification. Because in order to be a teacher, you have to fulfill the criteria which has been laid down, your lordship. And because of their non-fulfillment, they have been provincialized as a tutor. Now, I in my writ petition have particularly contended that I should have been provincialized because I have been teaching all along social science and English. I have stated in my writ petition as well, your lordship. Now, your lordship, the very bone of contention is that I was absent and I was negligent in my duty. Now, your lordship, in that regard, in my affidavit in reply, I have categorically replied that if there be the case so, that I should have been at least given an opportunity. There was a school managing committee's meeting wherein a resolution was taken as who is to be provincialized. Now, I also being a part of it should have been made up privy to that whole effect, but I was not done so. And they have annexed certain attendance registrar. If I have been negligent in my duty all along, I should have been terminated because my termination is purely, my appointment is purely temporary. And they could have terminated at any point of time, but which they have not done so. At the process of provincialization, I was not made aware of the provincialization process. They have secretly, in connivance with each other, have included their name, provided their names to the district scrutiny committee, which the district scrutiny committee has not looked into the matter. Now, had there been a careful consideration, your lordship, the services and the dice data is always prepared by the headmaster of the school. They have prepared their own dice data. They have included my name, and suddenly I have been dropped, your lordship. Lordship, that is the case now which has come into your lordship light.
What does the BTC say?
Your lordship, they have also stated in their affidavit in opposition, and they have annexed the attendance register. So from page 185 to 225.
Yes.
Yes, your lordship. And your lordship, if your lordship peruses page number 181, para 11. 181, para 11 of their affidavit in opposition.
Yes.
Your lordship, they had particularly taken the stand that my services were not provincialized because the petitioner was mostly irregular and unauthorized absent in discharging duties. So the second seniority was degraded by the school managing committee of the said school, and respondent 6 was selected as second senior teacher in place of the petitioner, and the respondent number 6, Sri Narad Chandra Brahma, was eligible for provincialization of service because he is overaged and also son of the landowner, who is the donor of the said school. The respondent number 6 and 7 and the petitioner had been joined the school on the same day, that is on 1/1/1993, and as per the date of birth of respondent number 6, he is senior to the petitioner, Dharani Chandra Brahma, and also the petitioner was physically absent from duty on that day as his signature was not found in the attendance register from 1/1/1993 to 29/1/1993, and May 2005, September 2005, January 2005, 7/3/2006 to 18/3/2006, January 2008, February 2008, April 2008, June 2008, September 2008, November 2020, and December 2020. Now that is the very essence of their affidavit in opposition, Your Lordship.
So you are irregular teacher.
If, yes, Your Lordship, if I was an irregular teacher, they are always at liberty to terminate my service, because my service is a purely honorary basis. The school was a venture educational institution. If I was so negligent in my duty, and there has been, I think, Your Lordship, number of teachers, so they could have terminated my service. Why wait till the date of provincialization, Your Lordship?
Yes.
Yes, Your Lordship. Now, as per the joining date also, Your Lordship, I am senior, and the Act in no way stipulates that seniority by age should be given precedence over any other eligible teachers, Your Lordship. Now, that is the humble case. I have made representations before.
Who is there?
Yes, Your Lordship. Your Lordship may very well peruse the manual at page number 115, Your Lordship, 114, section 4 of the 2017 Act.
Yes.
Your Lordship, teachers and or tutors to be government servants. Your Lordship, subsection 1, subject to fulfillment of all other provisions of this Act, the services of the teachers and or tutors of all venture educational institutions eligible under Section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette, and they shall become employees of the state government with effect from such date. Subsection 2 now, Your Lordship, the teachers and or tutors to be provincialized under this Act, Clause 1, must have been working as a teacher in the concerned venture educational institutions as mentioned in Section 3(1), Subclause 1, that have been recognized by the competent authority on or before 1/1/2006, must have minimum educational and professional qualifications as laid down under different acts, rules, and regulations as mentioned under Section 6 or any other relevant statutory provisions as the case may be. Now, Your Lordship's subclause 3 must have rendered at least 6 years continuous service as on 1/1/2017 from the date of joining in the concerned venture educational institution, which must be on 31/12/2010 or prior to that date. Your Lordship, this subclause is the main crux of the whole matter, Your Lordship. Now, in the earlier Repeal Act, there was no such provision as regards the subject-wise teacher. Now, this act has come into force with the requirement, and Your Lordship perused Section 3, subsection 1, clause 11, page number 111, is that, Your Lordship, there has to be 3 teachers: science and mathematics, social studies, and languages.
Where's that section?
Yes, Your Lordship, page 111, Your Lordship.
Yes.
Yes, Your Lordship, subclause 11, Your Lordship. In case of venture upper primary school, there shall be minimum 3 teachers or tutors, at least 1 teacher each for science and mathematics, social studies, and languages. Provided that for additional posts, it shall be considered in accordance with the norms and standards stipulated in the schedule under sections 19 and 25 of the.
What is this language?
Yes, Your Lordship. Now, Your Lordship, language depends upon the very venture educational institution, Your Lordship, is established by the people of the locality. Now, languages have to be understood in that particular essence, Your Lordship. For example, in a school which is a venture school in a Boro-dominated community or Boro majority community, Your Lordship, languages have to be considered in those aspects. Because, Your Lordship, if Your Lordship peruses the very definition of venture educational institution at section 2, it is an institution established by the people of the locality. Now, there has also been a claim by teachers who have also taught Assamese language that their services be also provincialized, and that is under consideration.
So basically, you are aggrieved because you are not provincialized.
Yes, Your Lordship. As a social science teacher.
Your name was recommended, not recommended.
Not recommended, Your Lordship.
From the basis.
Not recommended, Your Lordship. I was dropped from the recommended list, Your Lordship.
Then the district scrutiny committee did not consider you, right?
Yes, Your Lordship.
Obviously, state scrutiny committee.
Yes, Your Lordship.
So your name was not recommended at all.
Yes, Your Lordship.
Yes.
Yes, Your Lordship. So there is an error apparent on the face of the record, Your Lordship. Discretion being vested upon the committees which have been abused, Your Lordship.
The only ground that they have taken is that you are irregular.
That is the same ground which respondent 6 and 7 also have taken, that I was irregular. If I was be so, Your Lordship, then termination would have been the right way course, not till 2021 when the list was published. And the DIAS data is also the services record of the teachers who have taught in those.
No, that data is something that you are doing in the school.
Yes, Your
Teaching
Lordship.
so and so.
Yes, Your Lordship.
But then your attendance will not be shown in the DICE data.
Yes, Your Lordship. But Your Lordship, now the issue is that if I was so irregular, all along the way, if I was so irregular, I was unattentive, not taken care of the students' education, then Your Lordship, they always were at liberty, but not hanging till at end of the point. And two teachers who have taught Boro language cannot be provincialized simultaneously. Those are the grounds, Your Lordship.
Which 2 teachers? The respondent 6 and 7.
Yes, Your Lordship.
6 was teaching what?
Boro language and
maths.
mathematics. Yes, Your Lordship.
And 7?
Boro language and social science, Your Lordship. Primary subject number 1, which is the main subject, Boro, and second subject is social science.
Social science or social studies?
Social studies, anyways, Your Lordship, interchangeably. It means the same, Your Lordship.
This X says Where was that particular clause?
Yes, your lordship.
Regard to three teachers.
Yes, your
of,
lordship. Section 3, subsection 111, 111 page.
That's all.
Yes, your lordship.
Yes, Nayar?
हमारे 9 और 10 में 15 लेके हमारे अदर सोशल
Lordship, three things are clear, Lordship. One, both the petitioner and private respondent joined on the same day. So as claimed by the petitioner that he is senior to the other is not a correct statement. Both joined on 1/1/1993. So as per the law, Lordship, we can provincialize three teachers. One is holding the post of headmaster, Lordship, he is graduate. So his selection is automatic. Second, Lordship, one is holding teaching mathematics. So for the science post, he will automatically get selected. Remain two. One is the petitioner and the one other is the private respondent. So school management committee had to choose one between the two, Lordship. And what was the criteria the school management committee adopted? That is reflected in my affidavit, Lordship.
No, let us be clear. The headmaster is teaching.
He's thing into the social science नहीं किया था. Headmaster.
Headmaster was teaching social studies and.
Lordship, he is studying. He was provincialized against the post of social study. So one
Who is provincialization order?
recommendation, Lordship. It is in the affidavit filed by the government, Lordship.
Government affidavit. Government affidavit is respondent.
It's respondent number. Respondent number 2, Lordship. Respondent number 2.
No, respondent two is BTC.
BTC, Lordship. Here they have written as respondent number 2, but this is an affidavit filed by the Suranjana Senapati, Lordship. Suranjana Senapati is wrongly written as 2, Lordship. It's in fact 1.
Who is Saranjana Senapati? Respondent.
More can I get to
Chairman of this disciplinary student.
BTC. BTC अपने BTC 4 पर 3 पर आरंभ 3 4.
In fact, government is 2, Lordship. BTC is 3. Lord.
So you have.
In my affidavit, it is wrongly written as 3. So page 43, Lordship, of the government affidavit.
Page
43.
No, para. Where is 188C?
Para 5 law. That is the list.
Your lordship, I just trouble your lordship. As per the seniority list, lordship, I joined on the same day. Respondent 6-7 joined on the same day. I joined at 10:15 a.m.
That is not.
Yes, your
that
lordship.
is
As
not
per
material.
his submission, your lordship, I just
No,
have.
that is not material. Whether
Yes,
you
yes.
join at 10:15
Yes,
or
sir.
10:30.
Yes.
You joined on the same day.
Yeah, all three of them joined on the same day. I joined early at 10:15 a.m. Then.
That is a difference.
Yes, sir.
That is not right. Lordship, we had a criteria, Lordship, in paragraph 11 of my affidavit, I have explained.
Paragraph of your affidavit.
Yes, Lord. It is written as to page 181.
Oh, your affidavit is something else.
It is shown as by 2, but it should be by 3. Jagadish Prasad Brahma, Lord.
Yes.
Para 11, page 181. Okay, that as regards to the statements made in paragraph number 12 of the writ petition, the answering department deponent states that the Bodupa Upendranath Brahma ME School was provincialized on 4/1/2021, and the services of the employees were also provincialized. As it appears from the teacher's attendance register of the said school, the petitioner was mostly irregular and unauthorized absent in discharging duties. So the second seniority was degraded by the school management committee of the said school, and respondent number 6 was selected as second senior teacher in place of the petitioner, and the respondent number 6, Sri Narachandra Brahma, was eligible for provincialization of service because he is overage and also son of the landowner, whatever it is, of the said school. The respondents numbers 6 and 7, the petitioner had joined the school on the same day, that is on 1/1/1993, and as per the date of birth of the respondent number 6, he is senior to the petitioner Dharani Chandra Brahma, and also the petitioner was physically absent from duty on that day, as his signature was not found in the attendance register from 1/1/1993 to 29/1/1993. And these are the subsequent dates, Lordship. So this is the basic stand, Lordship. First, although they joined on the same day, Lordship, first, the petitioner was mostly remain absent in his duties. Second, the other one is age-wise senior to the petitioner, Lordship. That is the basic stand. Next, Lordship, I am coming to page paragraph 14.
Yes.
That as regards to the statement made in paragraph 15 of the writ petition, the answering deponent begs to state that the decision of the school management committee is the final decision. Next, that as regards to the statements made in paragraph 16 of the writ petition, the answering deponent begs to state that the headmaster had prepared and submitted the provincialization of service list for said school as per instruction decision of the school management committee. So that was placed before the district scrutiny committee, and ultimately district scrutiny committee made the recommendation. Now that recommendation is not under silence, that will be most vital, Lordship. If it is not under silence, then he cannot claim for provincialization of service. If your Lordship comes to page 185, Lordship. 185, same activity, Lordship.
Yes.
This is the attendance sheet, Lordship. The middle column is for Dharani Brahma, Lordship. Is the petition.
Where?
That A in AA column, Lordship, absent. Lordship will get his name at the top, Lordship. Name, Dharani Brahma. Middle one. 3 names are there. Lohit Chandra Brahma, Dharani Brahma, and Narad Chandra Brahma. 3 persons are there. Middle one is the petitioner, Lordship. Lordship, we see he is absent from the very beginning. Next page also, he is absent, Lordship.
This is which month?
Your lordship, 1/1/1993 till 29/1/1993. आपने ही पैराग्राफ तो लिखा है।
सही याद है डेट टू
मैं स्टेटमेंट
स्टेटमेंट है মানটো থাকিব লাগে ন?
Which month is this?
Month is not here.
মুহূর্ততে আছে ওটা মুহূর্ততে আছে ওটা মুহূর্ততে আছে
Month to sub.
আরব দুই
Attendance into.
Your Lordship, I pray that I reserve my right to reply, Your Lordship.
একটু জানুয়ারি 19 জানুয়ারি 19
No, this is your basic ground. That
Yes,
is
sir.
irregular.
জানুয়ারি 2004
Lordship.
again.
Page 186, Lordship, one date is mentioned there, Lordship. Will see at the top in the year to November 2020, Lordship.
Which one?
Page 186.
No, our pages are not telling.
Page 186 of the affidavit, Lordship.
Oh,
Just below the word register, Lordship.
yes.
Lordship will find the month November 2020.
জানুয়ারি
Okay.
So it continues, Lordship.
Yes.
But these are the two reasons. That is why, Lordship, but ultimately, Lordship, is prayer for provincialization cannot be accepted at this stage, Lordship, without setting aside the recommendation made by the district scrutiny committee. That is my humble suggestion. That is my
No,
understanding.
district scrutiny committee recommendation is not under challenge.
No.
Why you have not challenged?
Your Lordship, because Your Lordship, I have categorically stated, Your Lordship, that I was not, the issue of recommendation starts from the very fact that, Your Lordship, that there is a district scrutiny committee, section 13, the district scrutiny committee for elementary education, subsection 5, there are categories of persons who scrutinize the services of the records of serving teachers in venture educational institutions. Now, recommendation, everything has been prepared secretively. That is the whole stand which I have also taken in my writ petition. If I had known the recommendation, I would have directly made a representation before each and every authority, Your Lordship. After provincialization, the list of recommendation has already been done with, Your Lordship. Now, Your Lordship, this stand taken by the BTC that school managing committee's decision is the final decision, that would be contrary to law, Your Lordship. Because there shall be a district scrutiny committee in each district separately for elementary education of this who will to scrutinize service records and other related issues of the serving teachers. Now you cannot, Your Lordship, the district scrutiny committee cannot, on the basis of the recommendation of the school managing committee, cannot pick and choose. Then that would be the very in violation to the very fundamentals of Article
Let us see
14.
the minutes. Minutes.
Minutes has been placed before, Your Lordship. One copy has been.
Is the one?
Yes. Provincialization is the order of like. It was order to.
No, according to this, the school management committee has recommended the petitioner's name also, is it?
Not recommended.
Not recommended.
Your Lordship, that's the stand taken by the,
They are not recommended.
that's the stand taken by the BTC, Your Lordship, because the school managing committee's recommendation, Lordship has rightly pointed out and has pointed out by the Learning Standing Council at para
No,
14.
no, 1 minute, 1 minute.
Yes, sir.
The petitioner's name is there under the heading not recommended.
So not recommended means not recommended by the district's district scrutiny committee.
My lord.
Your Lordship,
So that means at least the name of the petition was put up. Is it correct?
Because they are considered,
If he was considered.
but not recommended. That is what like there.
Your Lordship, I'll just trouble your
No,
Lordship.
no, no, 1 minute.
Yes,
You
sir.
were considered by this district scrutiny committee, correct?
Not.
Huh?
His name was,
Not recommended.
Not recommended, it appears that he was considered.
yes, my lord. He was considered but not
Uh,
by the district scrutiny committee.
Your Lordship,
have you got a copy of this?
no, Your
You
Lordship.
will have to challenge this.
Your Lordship, in that,
You were considered by the district scrutiny committee.
Your Lordship, I'll just trouble your Lordship that as per the affidavit para 14 of 183 page, that just para 13, I shall start reading your Lordship once again.
Para?
From para 13, your Lordship,
Yes.
that your Lordship, that as regards to the statements made in paragraph 14 of the writ petition, the answering deponent begs to state that the format for report of district scrutiny committee, the said school was not able to fulfill certain criteria in the Provincialization Act thereafter. The district scrutiny committee had prepared the final list for provincialization of services as per decision of SMC. So as per decisions of SMC, school managing committee of said school. Now para 14, your Lordship, that as regards to the statement made in paragraph 15 of the writ petition,
No, no, 1 minute. SMC has put up the name of the petitioner to the district scrutiny committee?
no, your Lordship.
No, no, 1 minute.
Lordship, so far as my statement is concerned, SMC degraded him below the private response.
You got the minutes of the SMC.
No.
Let us have a look at that, then we'll be very clear.
SMC is not a party.
SMC. Party of
Party.
SMC.
SMC is a party here.
No, your Lordship. No, your Lordship. I directly challenged their appointment, provincialization.
SMC is not a party. My
Yeah, my
affidavit
But
has not yet been,
but can you somehow manage to get it?
Lordship, I can try. Lordship, I can try.
Your Lordship, their affidavit, respondent 6 and 7 has put out the resolution, SMC's resolution, that why my name has not to be recommended by respondent 6. I'll just take your Lordship for your Lordship's clarification.
1 minute, 1 minute.
SMC can also be made party.
Yes, my lord.
Otherwise, Lordship.
He is
will not
a
be able
necessary
to
party
pass an
here,
order
ma'am.
against the SMC committee.
Because if SMC has not recommended you,
Yes, sir.
then this court will have to pass an order.
Yes, ma'am.
setting aside the SMC recommendation.
At least now the petitioner is aware that SMC has not recommended it. This is scrutiny committee has not recommended it. So at least now he has the materials to challenge this order or not.
But that would not be, that would be, in my humble respectful submission, that would not be an issue relevant.
His simple prayer is provincialize my service.
Yes, your
One
lordship.
person has already been provincialized.
How do we provincialize your service without knowing the reason why the SMC has not,
One person has already been
has not put
provincialized.
up your name?
Lordship will have to satisfy the provincialization of the other person.
Yes, under the read jurisdiction, as per my humble submission, it can set aside. But your lordship may just well peruse 72 to 78 page number, the very resolution number of the affidavit in opposition filed by respondent 7. That would make the whole situation clear, your lordship. Annexure 23. That is the SMC's resolution.
Page?
Page 114 it starts, annexure 33.
Page 114.
Yes, your lordship.
No, but if some direction have to be passed, be that will be done. You should make SMC a party.
Yes. SMC and the headmaster.
You should make them a
Your
party.
lordship, I have made headmaster the party. Respondent, sir.
Anybody appearing for the headmaster?
The same.
I am a representative headmaster. Respondent number 7.
And 6.
Yes,
SMC, you'll have to make a party.
Your lordship, at that, my humble submission, the SMC, your lordship, at that particular point of time is not the either instrumentality of the state.
Yes, my lord, before provincialization.
Yes, the
SMC
whole issue was taken into consideration before provincialization. After provincialization, the situation would have been different.
SMC did
is a
not
very
recommend your
general
name.
Of a school man.
Did not recommend your name. So SMC is a party.
Before
You'll have to be heard.
I will implead them, your lordship.
A resolution adopted in 2018 can provincialize 2021.
Yes, your lordship.
Oh. Then you implead,
I will implead, your lordship.
file an application
Yes, your lordship.
in the IA, you write. After hearing the In the IA, he writes, after hearing the learned counsel for the respective parties, this court is of the considered opinion that between the interests of justice is consider and dispose of the men with petition at an early date. Inasmuch as if any decision is taken in the IA, the same would have a bearing on the merits of the manual. According to the law. Accordingly, which petition is taken up for hearing. However, learned counsel for the petitioner press for a short time to enable him to file an IA for improvement of the school managing committee of what school?
Your Lordship, Bodoka Upendranath Brahmo, ME School.
But now he is working in best school now.
Of yes. How much time you require?
Your Lordship, 2 weeks time.
2 weeks time, okay. Please the matter, 2 weeks. You keep this.
Much obliged, Your Lordship.
Let that order be put in the IA and the. Together you take it.
Much obliged, Your Lordship.
3. Implement of party.
My lord, this implement of party was on the last occasion, it was declined. My lord, will just, there was the order dated, last order dated 24th, my lord.
May I pray for taking up this matter after some time, my lord? So here
my lord.
will appear, my lord. After some time.
Yes, my good lord.
Upon. Then, my lord,
24/4/2024.
Yes, my lord. My lord will see that it was supposed to be taken up for today. The matter was hard at length. By Honorable Justice Q.K. Nair, my lord. That was. And today it was for my lord final disposal. That is there in the second part of the order, matter. And the will be made. So, my lord, regarding that infringement, my lord, he declined it, that it is not necessary. Those are not accepted in the order sheet, it was declined.
my lord, just keep it pending, my lord, implement petition, my lord.
So, my lord,
If it is,
What do you want now?
I am taking for after some time, my lord, but my lord, my learned senior colleague will, my lord. Who's the opening?
my lord, since the matter was hard at length, almost he reached a conclusion, my lord, in this matter. And that was why
Formal
the
hearing is not
So-
happened, my lord.
So, my lord, that is why it was fixed for today. So, my lord may, I'm just limited to your lordship. Either my lord will fix for next day, for my lord, this final disposal, or my lord may post it before the appropriate bench who has heard it, my lord.
My lord,
He has modified even earlier, he has modified this, there was an interim order that was modified even, my lord, by the same honorable judge without an application, my lord. We didn't file even application, the state didn't file application, but still he modified it. He almost,
but the matter was not, my lord, taken up as a part-heard matter. It was not in the order, my lord. So at this stage, my lord, may I pray to, you also may take up this matter and any other that if my learned senior colleague is paid for. Hearing, my lord. So it was not made part-heard, my lord. And it was in the, was not hard on length, my lord, and proper length, my lord. So initially it was hard, preliminary, it was hard, my lord, but it was not hard, for such period, my lord. So you also may taken up this matter, my lord. Because it was not made part-heard, my lord.
So you want to take up today?
Next week or any other date, my lord.
I am ready, my lord. If they want.
Because Mr. Yarvia is on leg in a hearing, my lord, in court number 1, my lord. Now, how much time it will take, my lord? He will appear, my lord, in this case, my lord.
Then my lord will post it in the next week, my lord.
Okay, then I'll say on both your.
My lord.
On request made by the parties. Please the matter up to 1 week.
My lord. Hello, please.
4. admission, partner.
My lord, on last occasion, my lord, argument was almost covered, my lord.
Well, on the last occasion, your lordship heard the matter. And I just submitted before your lordship that I will file an, my lord, the decision of the Supreme Court on the point that my learned friend argued that regulation 39, the punishment imposed on 39, if your lordship look at the regulation.
Today is the
39
not date for argument, my lord. Today is date for only submission of my lord. If he wants to argue, even me, my lord, I have to argue
You
that.
please hear me, then you say what I'm doing,
Only
Without-
submission of the
My
judgment.
learned friend should have patience, because he must know what I'm saying. Because he has said that regulation 39, we did not say under what provision dismissal was imposed. To that, my lord, the last occasion I said I'll place a decision of the appeals court. That is what I'm saying. It's not an argument. Whatever way it is an argument. My lord, he said there should not be an argument. I don't know what sort of language is this. Now, your lordship can be see regulation 39 of the Assam Gramin Vikas Bank.
I have supplied, my lord.
Yes. Your lordship may see 39, punishment was imposed on 39B. My lord, the management did not spell out dismissal, which is under B, my lord. Now, to that, my lord, my submission was, even there is not a specific provision mentioned, my lord, that will not vitiate so long there is a, my lord, jurisdiction of the management to come to that effect. My lordship may see the decision is 2004-12 SCC, page 278.
12 4 SCC.
2004-12 SCC, page 278, paragraph 9. It is paragraph 9, your lordship may look at. It is settled law that if an authority has a power under the law, merely because while exercising that power, the source of power is not specifically referred to, or a reference is made to a wrong provision of law, that by itself does not vitiate the exercise of power.
No, this is something else.
My lord,
This is something else which in the order, the source of power
my lord.
is reflected wrongly or
Or not
specified.
spelled out specifically.
But if the source of power is there,
Yes,
but here it's that under 39,
my lord,
there are so many penalties.
Exactly.
5 penalties.
my lord.
Now he does not know under which penalty has been given to him.
Impugn order is very clear, my lord, is a dismissal. Now dismissal comes under V. Now, I mean 5, Roman 5. Now supposing,
Let us see that impugned order once again.
yes. Your lordship may kindly come to page 121, madam. A departmental inquiry was held to inquire into the charges framed against you in the bank's letter of charge number so and so dated so and so. Observing the principle of natural justice, reasonable opportunities were given to you at the said inquiry for taking proper defense, and you also participated in the inquiry. I have carefully perused the records of the inquiry, day-to-day proceedings, evidences adduced, brief of both sides, findings of the inquiry officer and your submission thereon. I concur with the findings of the inquiry officer and satisfied with the evidences recorded at the inquiry, and have come to the conclusion that all the charges leveled against you have been proved and established beyond doubt. After considering the facts and circumstances of the case, the gravity of the proved misconduct, and your past reports, I impose upon you the undernoted major penalty in terms of regulation 39 1B of Assam Gramin Vikas Bank, regulation 2018 with immediate effect, the dismissal. Now, merely because clause Roman 5 was not added, does it mean, my lord, it will vitiate the entire proceeding?
That is the question. And the appeals court is saying merely because of non-mentioning or wrongly mentioning some provision, that will not vitiate so long the management has the power.
Yeah, but where the dismissal is there in the order,
My lord.
in the order, impugned order,
Yes, my lord.
dismissal is there.
Dismissal is there, my lord.
Huh? That-
Dismissal is there. That is true, my lord. But finding does not say so. What wrong I have done, the finding does not say so. Inquiry is totally silent, my lord. To that effect, I have come with the judgment also. Apart from that, my lord, non-submission of the affidavit in opposition, whether it will vitiate or not, another aspect, coordinate bench has held, my lord. I have come with the judgment also. Making submission on behalf of the bank, non-submission of the affidavit opposition, coordinate bench has held, my lord. Let him finish, my lord. I'll come within 5 minutes. An inquiry does not say anything about me, my lord. What wrong I have done.
In absence of that, how can you do that?
And in the absence of that, my lord, how come he can, my lord? The inquiry was conducted for misconduct 20 and something else, my lord, inquiry. Punishment is severe. And inquiry does not say so, my lord. What wrong I have done? Page 84, for a moment, lordship, kindly have a look. For a moment.
Let him complete.
Yes, my lord. Let him.
Now, if your lordship kindly see the inquiry report. The charge your lordship has seen, my lord, which is at page 52. My lord, these are all, my lord, established charges. In the inquiry, he was given a chance whether he want to cross-examine the management witness. In almost all the charges, he said, I don't want to cross-examine. That is the position. Secondly, my lord, in the inquiry, he was asked whether he want to give evidence. He said no. He did not give any evidence. He did not rebut anything. All the charges, my lord, has been proved. He did not cross-examine. He did not give evidence. Now they want to say nothing has been proved. My lord, where from they are saying all that? And the charge sheet, as the lordship has seen, all the charges have been proved. Then the report of the inquiry officer, the lordship may see at page 72 onwards.
No.
These are the charges one by one. All this, my lord, by giving all the credentials that has been proved up to, my lord, charge number 8. These are all proved. Then the last page at 84, hence it is proved that irregular disbursement were made by transferring the amount of loan granted to the self-help groups in an unauthorized manner to accounts of Javed Miadat, so and so, who are not members of the self-help group, violating the self-help group norms. Thus, he has done illicit transfer of funds, exposing bank to incur financial loss, and also putting the reputation of the bank at stake. During the inquiry, the CSO was not able to defend himself against any of the charges leveled against him, nor was he able to produce the documentary evidence in his support. Thus, all the charges leveled against him by bank's letter dated so and so has been established. Now, my lord, the inquiry proceeding. The lordship may retain that the last time I have shown. The lordship has seen all the charges where, my lord, in the inquiry, all the charges have been proved. Now, in every stage, he was asked whether he want to cross-examine. In against all the charges, he said, I don't want to cross-examine. What remains? And then he did not adduce any evidence. Then the question of regulation 18 and 20, how it is related. As lordship seen it last time also. The regulation 18 and 20, I will read once again. The lordship may look at regulation 18. Liability to abide by the regulations and orders. Every officer or employee shall conform to and abide by these regulations and shall also observe, comply with and obey all orders and directions which may from time to time be given to him by any person or person under whose jurisdiction, superintendence or control he may be time being be posted. Number 20, obligations to promote bank's interest. Every officer or employee shall serve the bank honestly and faithfully and shall use his utmost endeavor to promote the interest of the bank and shall show courtesy and attention in all transactions and dealings with officers of government, the bank's constituents and customers. Now, how he has conducted or discharged his service, my lord, the Supreme Court is very categorically said and what extent they should do and when it can be said to committing of misconduct. My lord, I am handing over two of the judgment of the apex court. My lord, I'll rely on 2005 6 SCC, page 321. In regard to, my lord, honesty, integrity and all that. Paragraph 21, madam. Coming to the question whether the punishment awarded was disproportionate, it is to be noted that the various allegations as laid in the departmental proceedings reveal that several acts of misconduct and becoming of a bank official were committed by the respondent. It is to be noted that the detailed charge sheets were served on the respondent employees who not only submitted written reply, but also participated in the proceedings. His explanations were considered and the inquiry officer held the charges have been amply proved. He recommended dismissal from service. The same was accepted by the disciplinary authority. The proved charges clearly established that the respondent employee failed to discharge his duties with utmost integrity, honesty, devotion, and diligence, and his acts were prejudicial to the interest of the bank. In the appeal before the prescribed appellate authority, the findings of the inquiry officer were challenged. The appellate authority, after analyzing the materials on record, found no substance in the appeal. The scope of interference with the quantum of punishment has been the subject matter of various decisions of the court. Such interference cannot be a routine matter. Now, Lord Green said in 1948 in the famous Wednesbury that when a statute gave discretion to an administrator to take a decision, the scope of judicial review would remain limited. He said that interference was not permissible unless these are the parameters, unless one or the other of the following conditions was satisfied, namely, the order was contrary to law, or relevant factors were not considered, or irrelevant factors were considered, or the decision was one which no reasonable person could have taken. These principles were consistently followed in the UK and in the India to judge the validity of the administrative action. It is equally well known that in 1983, Lord Diplock versus so and so summarized the principles of judicial review and administrative action as based upon one or other of the following, namely illegality, procedural irregularity, and irrationality. He, however, opined that proportionality was a future possibility. Now, in Kumar and others versus Union of India, the principle originated in Prussia in the 19th century and has been adopted in Germany, France, and other European countries. The European Court of Justice at so and the European Court of Human Rights at so have applied the principles. Now, these are the parameters where in a judicial review, your lordship can go into. First thing is there must be legality or irregularity. All these things they will, in this case, your lordship will not find any arbitrariness or illegality. Because the charge sheet has, your lordship has as much as 9 charges, and that has been established. They did not rebut anything. They did not give any evidence. So therefore, my lord, the punishment of dismissal is rightly given. There cannot be any other punishment below that.
Okay.
My lord, next judgment is 2005 1 SCC, page 13. I'll rely on paragraph 34 and 36. These I am citing in view of the argument faced by my learned friend on the regulation 18 and 20. Now, regulation 18 and 20 only speaks as a bank officer, it must be inbuilt requirement in your conduct that you must be honest. So therefore, 18 and 20 cares for that, my lord. Lordship, kindly see paragraph 34. The bank manager or officer and employees of any bank, nationalized or non-nationalized, are expected to act and discharge their functions in accordance with the rules and regulations of the bank. Acting beyond sworn authority is by itself a breach of discipline and trust and a misconduct. In the instant case, charge 5 framed against the appellant is very serious and grave in nature. We have already extracted the relevant rule which prohibits the bank manager to sanction a loan to his wife or his relative or to any partner. While sanctioning the loan, the appellant did not appear to have kept this aspect in mind and acted illegally and sanctioned the loan. He realized the mistake later and tried to salvage the same by not encashing the draft issued in the maiden name of his wife, though the draft was issued but not encased. The decision to sanction a loan is not an honest decision. The rule so and so is a rule of integrity, and therefore, as rightly pointed out by Mr. Salve, the respondent bank cannot afford to have the appellant as bank manager. The punishment of removal awarded by the appellate authority is just and proper in the facts and circumstances of the case. Before concluding, we may usefully rely on the judgment of prison manager versus so and so. If the charge employee holds a position of trust where honesty and integrity are inbuilt requirements of functioning, it would not be proper to deal with the matter leniently. Misconduct in such cases has to be dealt with iron hands, where the person deals with public money or is engaged in financial transactions or acts in a fiduciary capacity. The highest degree of integrity and trustworthiness is a must and unexceptionable. Judged in that background, conclusions of the division bench of the High Court do not appear to be proper. We set aside the same and restore order of the learned single judge, upholding the order of dismissal. Now, only thing, my lord, if you are a bank employee, which requires most is your honesty and integrity. Once you fail in that, my lord, all these things inevitable will happen. And it has happened in this case. So, my lord, I conclude my argument saying this. If my learned friend speaks something new, my lord, I will just return.
Right. My lord, I have come with a compiling judgment along with my lord bolded point, my lord. That your lordship can have a look, my lord. It did. Now, my lord, lordship kindly have a look again, my lord, 121. For a moment, my lord, last paragraph. That I'm coming, my lord. Lordship kindly have a look, page 121. Last paragraph, my lord. After considering facts and circumstances of the case, gravity of the proof misconduct,
Yes.
121 last paragraph. After considering the facts and circumstances of the case, gravity of the proof misconduct, and your past record, I impose you under the noted major penalty regulation 31B of the Grameen Vikas Bank, so and so regulation 21. Now, lordship will see punishment was imposed basing on two things. One is the saying that my past conduct and gravity of my misconduct. Now, lordship kindly have a look page findings of the inquiry officer. Operative part, lordship will see page 84. Now, my lord, then thereafter, my lord, I'll show one by one, my lord. Page 84. Hence, it is proved that the irregular disbursements were made transferred amount loan granted to so-and-so unauthorized manner to the so-and-so geniusally and who were not the member of the self violating the self-help group norms. self-help group notes, not bank. He has a illicit transfer of the funds exposing bank illicit financial loss and putting the reputation of the bank at stake. During the inquiry, CSO was not able to defend himself against any charges leveled against him, nor he was able to produce any evidence in his support. Thus, the charges level against the letter number has been established. Now, Lordship, kindly have a look. The charge number 1, what it says. Operative part, I am going, my lord, only. At page 72, relating to charge number 1. And findings, Lordship will see at page 74. Page 74 relating to the charge number 1. This is proof that Lordship has come across page 74 in respect of the outcome number, charge number 1. It is proof that the same group photographs were accepted in the loan documents, though they had different group names and group members, and fictitious loan were stated in charge number 1B. Now, my lord, what is my role? That is totally silent. Who has done? That I'm coming, my lord. Now, similarly, charge number 2, Lordship will see page 77, top, my lord. This is the outcome of the charge number 2. Thus, it is proved that KYC document of all the members help group in charge number 2 were obtained, and those obtained in the bearers of the groups found to be fake and tempered unauthorized self. Thus, the breach of emergency performed to the verification identity of the customer. What wrong I have done? Nothing mentioned. Similarly, charge number 3, Lordship will see at page 78. 78, just above the charge number 4. Thus, it is proved that individual has joined multiple self-help group and availed multiple loans, violated the Reserve Bank of India guidelines on the self-help group. This is only self-help group, nothing against me. Similarly, charge number 4, outcome is at page 79. Above, Lordship will see above charge number 5. Thus, it is proved that Lordship has come across. Thus, it is proved that drawn checks were issued or transferred to the account of some other individual self-help. Also, withdrawn slip were used as a transfer voucher of transferring huge amount of different saving account of self-help group, being the amount of disbursed to the saving account to other individual self-help group. This does not authorize transfer of loan disbursement amount. This also does not go against me. Finding nothing recorded, past record or misconduct. Now, Lordship will see charge number 5. Findings, your Lordship will get at page 81. Above charge number 6. Also, group photographs attached with the loan document management evidence number 6D is also found attached with the loan documents ME so and so on Dulal Haq, whose voter ID is present in one of the authorized signatory in both Kushal Kaur self-help group, JK self-help group is present in both self-help group, had availed the benefit of 2 loans, deceiving the bank. There also, my lord, no, this is regarding to the self-help group, not relating to the bank manager as a me. Now, charge number 6, that your Lordship will see page 82. Above the charge number 7. Thus, it is proved that an approved and fraudulent transaction was made for amount of so and so was misappropriated from the saving account of Joymati self-help group. There also nothing says about me. Now, Lordship, charge number 8, page 83, above charge number 8. This is proof the term deposit were created out of the installment disbursed which implicate the bank loans were diverted no primary assets created as a scheme under financial cumulating accounts turns to the NPA. This also nothing says against the present person, my lord. Charge number 8, my lord, and 84, they have said, my lord, it is proved. Where is the misconduct, my lord? In the entire inquiry, I have shown, my lordship, 8 charges. There is nothing, my lord. Now, lordship, kindly turn to I have given the judgment, my lord. What is the consequence of not filing affidavit in the writ proceeding? Coordinate bench held that, my lord, that your lordship will see, that your lordship will see para 4, serial number, page number 4, para 4. May I read, my lord? In the case, notice of motion was issued on so and so. However, no affidavit opposition has been filed. Learned standing counsel for the so and so department has submitted that he has received the written instruction made attempt to refer the same. In this regard, the court is of the considered opinion that having not been filed an affidavit opposition, the respondents are precluded from referring to their parawise comments as adopting that such procedure would deprive the petitioner having knowledge of the stand taken by the respondent authorities. They would be taken by surprise. That is the consequences of non-filing affidavit in opposition. Now, lordship will see another judgment, my lord. I have referred of the coordinate bench. Coordinate bench that your lordship will see 7, my lord. I am speaking that, my lord. Now, important part is serial number 3 of my argument, my lord. From the perusal of the article charges, it is seen there are the statement of allegations contained therein. There was no specific charge frame against the petitioner within the regulation 39. That apart, there is no any finding recorded by the inquiry officers. Page 77 onwards of the writ petition. The writ petitioner has violated any regulation of the bank or has acted in a contrary to the interest of the bank, has shown inefficiency or found guilty or other form of misconduct, including breach of discipline, etc. That about the evidence that there are other organs of the bank which were actively involved in the processing the loan, which included the inspection team. There is nothing to as to what manner and what other such official has disturbed their since the law is involved in the present case is Rule 10 to that staff accountability policy. That I'm coming, my lord, coordinate bench judgment, my lord. Lordship, maybe your that Jamadar has come back behind.
Fine.
Fine, Mr. Since the law involved in the present case, clause number 10(2), Assam Gramin Vikas Bank staff accountability policy are concerned, the same has not been taken into account to inflict punishment under section under Rule 39(1)(b). Inquiry officer failed to record any findings that the petitioner had violated any regulation of the bank or has acted a manner contrary to the interest of the bank or has shown inefficiency or is found guilty of any form of the misconduct, including the breach of discipline. As such, petitioner was not only sole person for proceeding a loan, which ought to have been caused an inspection under clause so and so. That about appellate authority. Lordship, kindly mark this point. The appellate authority did not pass a reason order. Rather, facts were submitted by head of the department by writing the facts only. Appellate authority written one-line order, page 143. And that, my lord, lordship will see, which I brought on additional affidavit, my lord. It is the fact written by somebody else, and my lord, appellate authority said only one line, my lord. On the top of that, my lord, that your lordship has already seen, my lord. Additional affidavit, lordship will kindly take up page 143. Serial manners. Yeah, my lord, lordship will. On the top extreme left. Decision of the DA is logical appeal not to be considered. This is his order. And after that, my lord, page 144. It was the facts was placed by two persons. Head of the department vigilance, general manager. Above that, my lord, place before chairman, appellate authority for kind perusal and necessary advice. But my lord, bank authority, my lord, misrepresented their side, the considered. It is not that, my lord. That last page you will see. Last page of my writ petition, my lord. Now, lordship will see in the similar circumstances, my lord, our coordinate bench was held, my lord, that your lordship will see. Will see. I have bolded, my lord, serial number, page number. That, my lord, document number 3, page 21 onwards. Operative part of the paragraph is 10, 13, 15. What says about, my lord? Similar circumstances of the bank authority, my lord. Bank authority, my lord. Page 30 is the, my lord, the findings of that case, my lord, similar. Then
Yes.
yes. Para 10, my lord, as has been noted herein, the inquiry officer had found that the first 3 charges brought against the petitioner, these charges pertaining to the Mrs. So and so, were partly proved, whereas the remaining charges were found to have been not proved. Based on the aforesaid inquiry report, chairman of the bank, who is a dissenter, had imposed following penalty of the petitioner, my lord. When reduction was there, then lordship will see para page 32. That is also identical in my case, my lord. Page 32, para number 13. From the careful reading of the articles of charges, the court finds that although there are the statement of allegation contained therein, yet there was no specific charge. No specific charge framed against the petitioner within the meaning of Regulation 39. From the charge memo, it is not clear as to what manner the alleged lapses would amount to misconduct within the meaning of Rule 39. There is also no finding recorded by the inquiry officer that petitioner had violated any regulation of the bank or has acted in a manner contrary to the interest of the bank or has shown inefficiency or is found guilty any of the form other than misconduct, including breach of discipline leading to the loss being suffered by the bank. All the articles of charges indicated there are certain lapses on the part of the petitioner in the failure to verify the certain documents on record, which he ought to have done as a matter of recommending the authority. However, what is to be noted here in as per the material on record, no point of time was the petitioner individually, my lordship, kindly note down that point, individually possessing the loan, as he has all along a part of the team recommending committee and which had processed the proposal. That apart, this is that what, my lord, I said, the credit officer, he is also person, my lord, in the line. That I have taken plea, my lord. Since they have not filed the affidavit in opposition, there is no scope, my lord. He has to accept it, bank authority. It is the evidence from the materials on record that there are other organs of the bank which were actively involved in processing loan, which included the inspection team. There is nothing on record to show as what manner such other official had discharged their responsibility in the processing loan. Who, how, when, my lord, it was done, it is being totally silent. Then lordship will see paragraph 15 and 18, my lord. That your lordship will see page 33. Coming to the other argument advanced by Mr. So-and-so, relying on the so-and-so Assam Gramin policy, the policy further, it is the investigation conducted subject to the regulation inspection after sanction disbursement, audit credit facility, no fresh pre-sanction lapse or other this thing. There, my lord, they have not caused any inspection by the team, my lord. This document has been forged or unaccepted or this thing not in accordance with law. To that effect, my lord, no inspection for which there is no FIR. And now, my lord, in the read code, there is no affidavit. The time shall not be applicable, so and so. Then, my lord, lordship kindly jump up to page 34. It is the page 34 paragraph coordinate bench held. The petitioner has also taken plea violation of the principle of natural justice due to non-furnishing of the relevant documents. Relevant documents, page 99, 100, I made a categorical statement, my lord. I have taken due acknowledgement. You supply me particular documents, page 99 and 100. And I don't know, my lord, what is there in the record. Documents along with the charge sheet, however, such allegation has been denied, disputed by the bank, be that it may be. For the reasons indicated above, this court is of the unhesitant opinion that the departmental proceeding conducted against the petitioner was not only in the breach of embargo of clause number so and so accountability policy, but some has also conducted violation of the principle of natural justice as well as the provision of the service regulation, thus causing serious prejudice to the interest of the petitioner, that apart no justifiable ground for the district to impose major penalty. Major penalty upon the petitioner, as indicated above. In the result, the succeeds and allowed the order of the penalty is hereby set aside. Accordingly, my lord, then lordship will see document number page 63, my lord, para 6. It is the relating to the apex court decision, my lord. Page 36. Para 6, my lord. Is a particular case, my lord, where the my lord, these things has not been reading the rules number so and so together with the language employed therein clearly discuss that preliminary inquiry is held only in the case of the allegation which were
You are reading from where?
page 39. It is from apex court, my lord, in respect of SCC 2007 volume 9. Page 39, lordship will see reading a rules of so and so inquiry held only in case of allegations which are weak character, and therefore preliminary inquiry is to be held to establish the nature of the default, identity of the defaulter, to collect the prosecution evidence, the judge quantum of the default, and to bring to the relevant documents on record to facilitate regular departmental inquiry. In the cases where the specific information is available, preliminary inquiry is not necessary and departmental inquiry may be ordered by the disciplinary authority. It has because of the reason that so and so conduct in a very such defense delinquent officer, the additional commissioner of so and so hereby is approval of the mandatory. So relinquent of the officer is not prejudice to the harass unnecessary departmental inquiry. Such approval, if any, accorded after the application of mine, it is the case of the violation of the mandatory provision of the. Therefore, the appeal must succeed the in dismissal order preceded so and so by the inquiry. Basing on inquiry, my lord, subject matter is the order of the dismissal is set aside. Here also same case, my lord, apex court held, my lord, particular parameters was not followed. It vitiated, my lord, that has been set aside. Thereafter, lordship will see the serial number 5, my lord, at page 1. That judgment, lordship will see at page 41. Page 41, para Kemandisa. 13 and 15. Lordship kindly turn to page 41. 41, my lord. Article, this is 111 to the proviso, this the copy of the inquiry and submitted by the to disciplinary authority and make a representation against it. No furnishing report to the delinquent will find the order invalid. Here also said invalid, my lord, non-supply of the documents. I have given already typed copy, my lord. Also can have a look. Just thereafter, my lord, another judgment of the apex court, which was reported in 1995, supply 1. That your lordship will see at page supply page 52, my lord. It starts from page 52, operative part. Operative part is para 4, my lord, which your lordship will get at page 55. If your lordship permit me, I'll just read out, my lord. Mr. So-and-so first involved our attention of the observation made by Lord Rigid in the Rigid Baldwin in at page number 81 to the following effect. I need to consider what the result would have become being as Secretary of the State has heard in the case the appellant and then given his own independent decision that appellant should be dismissed. Mr. So-and-so, the inherent observation that the view that the effect that could not have been cured secretary and share of the final decision on the basis of the record without being influenced by the decision impugned there before him. We do not think that it would be permissible to draw such influence that cannot be said to be the ratio of the decision. The learned single judge himself says that in so many words, he does not consider what he gave have been result if necessary given in the independent decision. The decision could have been gone one way or the other. Therefore, the above observation does not help the Mr. So-and-so. It is the defect. If the defect is one which goes to the root of the manner and which is incurable, cannot be remedied by the higher authority taking decision independent of the appellate authority rendered by the decision of the so-and-so reported so-and-so. It was concealed that the disciplinary authority had not followed the requirement of the natural justice. The question which posed consideration was, can a deficiency of natural justice before trial tribunal is cured by the sufficiency of the natural justice before an appellate tribunal? Megari Justice, after stating that the sheet should be made to clean the possible, I think it should be same as sheet does not different one proceeded to edit so and so. Then it is recorded, my lord. Then the next page, my lord, page 56, last paragraph, just near to the G. In view of the matter, the court considered decision that the appellate authority could not cure initial defect of the constitution of the inquiry committee and consequently following one of the member of the inquiry by being biased in view of the matter with the appeal was allowed. Here also same thing was happened, my lord. I did not big judgment, my lord. Thereafter, my lord, another judgment I have relied, my lord, which I have downloaded from live law, that your lordship will see page 58 onwards, paragraph 10, my lord. Is the recent judgment of the apex court, my lord. Paragraph 10, that your lordship will see at page 65. It starts from page 64, para 8, my lord. It appears from the order passed by the tribunal also observed that the inquiry proceeding initiated against the principle of natural justice, inasmuch as document mentioned in the charge sheet were not at all supplied to the delinquent officer as per the settled proposition of law in case where it was found that the inquiry was not conducted properly or the same is the violation of the principle of natural justice. In that case, the court cannot reinstate the employee in such a manner so-and-so inquiry officer disciplinary authority to propose further inquiry from the stage of the violation, principal justice is noticed. Because in the case, my lord, I have already died of accident during my service. When I was alive, my lord, my retirement period was there. An inquiry was to be proceeded further, furnishing necessary document mentioned in the charge sheet, which was alleged to have been delinquent officer in the instance case. In the case of Chairman versus Life Insurance Corporation of India and Muslimani 2013 6 SCC, which is pressed into service on behalf of the appellant before the High Court. It is observed that the paragraph 16, it is settled provision of the law. Once the court set the order of the punishment on the ground, inquiry is the properly conducted. The court cannot reinstate. I don't want reinstatement, my lord. It is the remit the concern to discipline authority for its conduct inquiry from the point of initial budget, so and so include, and several judgment has been reproduced, my lord. Then lordship come to page 66, para 10. In view of the discussion and for the reason stated, the findings recorded by the tribunal as well as the High Court quashing and setting aside punishment imposed by the disciplinary by applying the doctrine of the equality is hereby quashed and set aside. However, inquiry officer found to be vitiated and found to be in violation of the principle of natural justice in much as that the relevant documents mentioned in the charge sheet were not supplied to the delinquent officer. We remand the matter, then matter was remanded back, my lord. Thereafter, my lord, another judgment, my lord, is relating to the Karnataka High Court, my lord, that your lordship will see page 68, operative part. Your lordship will see para 14, which is at page, which is para 14 at page 82. This court, in the light of the landmark judgment cited supra, recognize the fundamental importance of an impartial and independent disciplinary authority in ensuring the procedural fairness and upholding the principle of natural justice. The role of the disciplinary extend to the beyond mere adherence to the procedural formalities. It is necessities that the exercise of the independent judgment free from undue influence or bias. The respondent number so and so lacking autonomy, freedom in view of the recommendation of so and so. Therefore, the impune penalty imposed by the respondent number 2 in compliance of the dictate governing council is not central. For the reasons stated above, the process passed the following. The writ petition is allowed. The impune penalty, compulsory retirement, so and so was annexed hereby quashed. Now, my lord, lastly, another apex court decision, my lord, 2007, volume 7. That your lordship will see at para 18. Para 18 is stands at, my lord, at page 92, my lord. Only operative part I am reading, my lord. After going through the report and finding recorded by the division bench of High Court, we are of the opinion that in fact, the division bench correctly assessed the situation where the respondent alone was made scapegoat, whereas the decision in all three committees were unanimous decision by the DIS members, particularly in the negotiation and price was finalized accordingly. It is not the respondent alone can be held responsible, and when the decision was taken by the committees, it is the decision of the committee stinks. It cannot be said that the respondent alone stinks. It will be arbitrary if the fish is sink to pick up one and say only the sinks is the unfair manner amongst the decision of the committee. Here, my lord, what happened, my lord? Several persons was involved, my lord. One particular person, as like the petitioner, was chosen and he was penalized, my lord. Thereafter, my lord, the appeal filed by the authority, my lord, it was not considered. It was the Bangaigaon refinery, my lord. In the some, my lord, that was not considered. The decision of that taken was upheld, my lord. It was the apex court. Now, my lord, in the light of all the decisions which I have relied upon, as the Supreme Court as well the High Court, various High Courts also, my lord, whatever the bank authority has relied upon the judgment, my lord, I have come occasion to access it, my lord. It seems to be, my lord, there was a misappropriation of the fund in all the cases relied by the other side, my lord. But here in the instant case, my lord, lordship will find there is no any whisper what wrong I have done, which was found by the inquiry officer. He found this document deficiency, this document deficiency, this document deficiency. Whether for this document I am answerable or who is answerable. Credit officer is also there. On top of that, my lord, they did not file the affidavit. So how come, my lord, I can rely upon the records produced by the respondent bank and this honorable court? I am not free access to this thing. And had it been, my lord, I have been given the document, I would have not written them, my lord. They have ought to have passed the order basing on my application. You supply me copies. I have approached 2 occasions that a material exhibit 6 number so and so was required to be supplied to me for defense. If they do not supply, how come I can cross-examine? And all the inquiry, lordship will see 8 inquiries. What lacuna or what wrong I have done? That is totally silent. An impine order which lordship will see at page 121 does not say so, my lord. They are saying on the requirement. Now, lordship, kindly have a look. Another thing, my lord, last page of the writ petition, my lord. How come, my lord, the bank authority making misleading documents to the own staff, man? That your lordship will see page 138. 138. Last page, man. Annexure 18. Page 130. Last paragraph, my lord. Accordingly, lordship has come across. This is the first, second, third paragraph. Accordingly, careful pursuing the records, inquiry evidence adduced by the considering the facts of the circumstances of the case. The chairman and the appellant authority of the bank has disposed of the appeal petition of late Mukul Chandra Sharma, upholding the decision of the general manager disability authority of the bank, finding the same as impartial and appropriate. This is for favor of your information. And now, my lord, this document, the page 143 says something, my lord. From where he got, my lord, impartial appropriate. Not a single. He of his own, my lord, being a head of the department, he has of his own, he has written. Page 143, 44, we'll see. Head of the department placed the matter for approval and for a appropriate order for consideration. He did not say anything. He said logical, so appeal cannot be entertained. That much only. And now, my lord, this person from where he has got, I don't know, my lord. Had it been supplied to the court, my lord, would have become a perjury, my lord. But it is unfortunately it was submitted to the petitioner's wife, widow wife. That also, my lord, played my game. Meaning thereby, my lord, over and above, in supporting of my document, my lord, the decisions I have placed before your lordship. Prima facie, it is a bias. There is no FIR, there is no cogent and reason order, and there is no, my lord, single word has been used, dismissed from the service. 39, my lord, there is other provision is also there.
No, you.
Dismiss have been issued, basing on what? That your lordship has to examine in the light of this. They said, my lord, dismiss on misconduct.
No.
Dismiss on 121.
Come page
21. 121, this is the dismissal order. Last line, my lord, last paragraph. After considering the facts and circumstances of the case, gravity of the proof of the misconduct, and your past record. Where is the past record, my lord? So there is no finding on me that your past record was done. This thing you have been done, you have committed wrong. I impose you under the noted major penalty in terms of regulation 39 1B of Assam Gramin Vikas Bank regulation with immediate effect, dismissal. In the bold, they have written dismissal. But now lordship will see where is the finding of the inquiry officer, my past record or my misconduct. Inquiry officer never said. He said this document does not tally with the self-help group. This document does not tell you with it. Who is answerable for that? It is inquiry officer totally silent because, my lord, credit officer in every bank is there, my lord. His job is only to supervise, to see what document they have supplied. Then, my lord, the matter is placed before, at the end of the job, my lord, matter is placed before the manager. Suppose I have opted for some loan, I have supplied my document directly, I cannot go and give to the manager. There is some officials involved. Inquiry officer did not say, my lord, that this was your job, you did not do. That was never said. In field verification also, my lord, it is not there. And I have categorically denied, my lord. And over and above, the entire proceeding vitiated, my lord, in the light of the judgment which I have referred before your lordship, my lord. I don't want job because I am no more alive. So all the monetary benefit I am entitled to get by quashing the impine order in the light of the decision of the various high court, including coordinate bench of our high court, as well as the apex court, my lord. Once they have declined to file affidavit, consequences, coordinate bench held that, my lord. It is decided by the coordinate bench. The implication of non-filing affidavit. In that case, it is been taken, my lord. Apart from my argument, I am saying, my lord, if it is so, my lord, allowed to run like this, my lord, no department will file affidavit. They will say, I'll bring the record. But I got to say, I'll say it from the record. But what will happen to the petition? That's why, my lord, honorable coordinate bench rightly held, my lord. It will be surprise on me. It will be against the principle of natural justice and equity, my lord. So that's all, my lord. Lordship has to remember 3 things, my lord. The inquiry report, what finding, no FIR, nothing, and some documents I have not been supplied with, page 9900. I have given to them, my lord. There is no speaking order. Why they have not supplied? And there is no allegation against me, against the misappropriation of the fund. And it is a very harsh punishment. That apart, my lord, which was intimated by the page 138, my lord, of his own motion, he said, my lord, it was considered so and so thing, but appellate authority, only single word was used by him, that I have brought into record by way of additional affidavit. My lord, it has to be applied in the judicial mind, my lord. To that effect, I have given several judgment also. Lordship is also aware. Once I have filed a petition, my lord, either accept or reject, there has to be cause and reason. It is not that, my lord, that DA cannot be, appeal cannot be accepted. That cannot be. It is against the mandate of law. Appellate authority has to write something. Either way, reject or accept. Accepting, he has to give reason. Rejecting also, my lord, he has to give reasons. And one line, my lord, it is not even provided in the British rule also. One line word, yes, you die. That cannot be. Yeah, in the case, my lord, on the other day, my lord, my learned senior friend has relied about some Julius Caesar or something else. But here, my lord, the principle of natural justice has not been followed. Had it been not there, my lord, Julius Caesar or my lord they were deprived of principle of natural justice. That was not discussed. In the story, I can remember, my lord, whatever I read my school days. That's all, my lord. In view of the above, my lord, and findings of the court, lordship is there to pass, my lord, really. That much, my lord, nothing beyond that, my lord. I have not gone into and only basing on record, I have made some. And I am a widow, my lord, at this stage. I am struggling alone. Nothing I got to survive.
I'll just take 5 minutes. Lord, much has been spoken so for filing of affidavit. Now, my lord, first time in my life I have heard if no affidavit is filed, it will go against the bank. Now, this is subject to the condition. When the record is before your lordships, there is no need of filing any affidavit in the sense. Well, we are not going to say anything beyond the record. And your lordship is aware. So far disciplinary proceeding is concerned, your lordship will concern with the charge sheet, the reply to the charge sheet, inquiry report, punishment order, and above all, my lord, the record of the disciplinary proceeding. Now, where is the question of affidavit, my lord? Affidavit, I may say so many things, blah, 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 on that. But these are not taken into consideration by the court. Because ultimately your lordship is concerned with the disciplinary proceedings record. Therefore, if my learned friend can satisfy your lordships that there is a law in that, unless the affidavit is filed, the bank will have no case and the case will be in their favor. If any decision on that regard can be placed, my lord, I don't think any of the dishonorable court or the appeals court has passed any judgment in this regard and cannot be passed. So therefore, question of affidavit is a quite unnecessary question. Now, my learned friend has said that he has no access to the disciplinary proceedings record. My lord, a record is always given to the delinquent. And my lord, therefore, he has said he in the charges and my lord, the records of the disciplinary proceeding conducted by the inquiry officer, the delinquent could not be linked. He cannot be connected with the charges. Now, possibly, my lord, he did not go through the record of the disciplinary proceeding. That's the reason. That's the reason he has stated that. Now, my lord, I'll take your lordships to the pages where he was connected with the charges. Now, your lordship may see page 9. I have marked it, my lord, page 9. Page 9 is relating to KYC. Now, the last 4 or 5 pages I have tick marked. Page 9, my lord.
1 minute. This is regarding KYC.
KYC. My lord, a few of the charges I'm just highlighting, my lord, how he has been connected. Now, the tick mark portion, your lordship, down below, kindly see. Deciding officer, please go through the documents ME so and check whether KYC documents of all group members are available with the documents. MW1, there are copies of PAN card of so and copies of voter ID card of so and so available with the loan documents. PO, please go through the documents ME and check whether signature of the verifying officer of the KYC documents of ME 5G matches with the signature of the CSO, that is charge sheeted officer. Yes, the signature of the verifying official of ME 5G matches with the signature of CSO. He is totally connected with this offense, my lord. And he was asked whether he want to say something in regard to this, whether he want to cross-examine. Now that your lordship will find at page 12. Page 12, your lordship, in the middle part, tick mark portion. Please go through the documents ME4 and check whether signature of the verifying officer of the KYC documents of MF matches with the signature of the CSO. MW1, yes, the signature of the verifying official matches with the charge sheeted officer. Now, how they are saying that he could not be linked? And then the next page, at page 13, tick mark portion, your lordship kindly see. The inquiry officer asked the CSO if he would like to cross-examine MW1. The CSO said he would not cross-examine MW1. Now, in the reading from the inquiry report, he's showing that he could not be linked with these charges. Now, the reading of the disciplinary proceeding, my lord, he has candidly said that all these things were there, but I don't want to cross-examine. Then, my lord, your lordship may skip the other pages and kindly come to page 15, my lord. This is in regard to self-help group. As your lordship has seen in the chart, my lord, in the self-help group, my lord, one member can be only with one of the self-help group. But here, the 3 or 4 of the members in so many self-help groups. Now, your lordship will find that PO, presiding officer, please go through it is in the last part your lordship will find. Please go through the ME6, MECCT and MECU and tell the inquiry officer whether Farida Begum is a member of all the 3 self-help groups. MW1 replied, yes, Farida Begum Ali is a member of all the 3 SHGs. Now, likewise, your lordship will find the next page also. In all these, my lord, one member happens to be 3 or 4 members of the self-help groups. Then in page 16, the last lines, my lord. The inquiry officer asked the charge sheeted officer if he would like to cross-examine MW1. The charge sheeted officer said he would not like to examine MW1. Now, my learned friend argued so long that he has not been linked with the charges. Then page I'll take your lordships to page 31. Is regarding dormant inoperative account. Now, charge sheet officer is very clearly linked with this. Your lordship may see the tick mark portion. Presiding officer, please go through ME1 and ME13 and tell inquiry officer whether the dormant inoperative SBI account number so-and-so of so-and-so was activated on so-and-so. MW1 replied yes. Please go through so-and-so who have activated the account. The account was activated by so-and-so and authorized by the charge sheeted officer. Now what remains, my lord? In all the charges, my lord, charge sheeted officer have been linked. Then, my lord, then in the page, next page, page 32. In the middle portion, inquiry officer asked the charge sheeted officer if you would like to cross-examine MW1. The charge sheeted officer said he would not examine MW1. These are all end of the matter, my lord. Then the page 36, after the end of the inquiry, the inquiry officer asked the CSO in the middle portion, your lordship will find. Inquiry officer asked the CSO if he would like to cross-examine MW1. CSO said he would not cross-examine MW1. Inquiry officer asked the PO to produce his witness if any. PO replied that he has no other witness. Then inquiry officer informed both the sides that if they have nothing more to examine or re-examine, he will come to the conclusion. Both the sides declared that they have no more to go ahead. Now, my lord, here the delinquent could have, my lord, give his evidence that this is not my signature. I did not do all these things. My learned friend has argued that there are some other officer like credit officer and all that. They might have done. Might have, would have, could have. These are applied in economics, my lord. Here, when you are coming before the disciplinary proceeding matter, you must say whether you are involved or not. If you want to say I am not involved, you will have to say I am not involved. You will have to produce your document to show that by you have documentary evidence that he was not there at all. Now, these things are totally lacking. Now, he has said that the other officer were there. Who are those other officers? Did he say? No point of time he said he even did not cross-examine in any of the charge sheet. Now, in the end of the the disciplinary proceeding matter, the inquiry officer asked him, both the parties, the prosecution as well as the defense side. Now he said, I don't like to give any evidence. Then after that, my lord, these charges, your lordship has seen, the charges are very grave. Your integrity, your honesty is in question. You did all these things at your whims. Now, when your integrity is in question, your honesty is in question, can a person like him to be retained in the bank? My lord, he has shattered the confidence in all ways. And because of that, my lord, this punishment, dismissal is an appropriate punishment when your conduct is like that, that you do not have any, my lord, potentiality to be accepted as a bank officer. My lord, that day I have shown your lordship a judgment, my lord, that regarding Caesar's wife. Caesar's wife must be beyond any suspicion. Likewise, my lord, the bank officer, bank's accountant, everyone will have to be beyond suspicion. Now, here I have shown the bank manager, State Bank of India manager. He has merely just granted sanctioned loan in the name of his wife. The moment he realized that it is beyond his power, he cannot do that. My lord, he was removed from the service of the bank because these sort of people cannot be relied. So they are dealing with the public money. So that's the reason, my lord, here, what, my lord, he has committed number of at least 9 possible times. He had flouted the norms of the bank. And my lord, under these circumstances, the inquiry was held, every chances was given to him. All the procedural formalities were totally observed. From nowhere, my learned friend can show that here is a case, is a case where the natural justice was not followed. The relevant formalities were not followed. He said documents were not given. My lord, your page 3, your lordship kindly see, he has himself said. Inquiry officer asked the defense side if they verified the documents as listed by the PO. The defense side replied that they verified the documents and submitted certificate to that effect, that your lordship will get at page 3. Now, wherefrom he said that no document was given to him, therefore he could not cross-examine. Well, you did not cross-examine the MW1. You did not examine yourself. And now you say, had I been given those documents, then I could have cross-examined. So could have and should have, my lord, those concept will not apply here. So therefore, my lord, the case where he has been dismissed quite rightly, and the, my lord, the appellate authority, my lord, if your lordship sees the additional application filed by learned friend, my lord, they have given the reasons why they have dismissed the appeal. Therefore, even in that context, also appellate authority has applied his mind. My lord, chairman has given his decision and has said that he is satisfied with the reasons given below. Therefore, dismissal is a proper punishment was imposed.
This is not the decision.
That's what my.
My lord, just one line addition is that, my lord. Whatever the document my learned friend has relied before the court, my lord, they are totally silent about my document, which I sought for the document, page 99 and 100, my lord. I asked particular exhibit, my lord, whether this record reveals that the particular document which I sought for in page number 99 and 100. '99, 100 and 102, my lord. 4, 5, 6, 7, material witness 3. These are, they have duly acknowledged, my lord. 99 to 102, 2 occasions I have given, totally silent. That's all, my lord.
Okay. Is that what is part of that?
Obligement. Judgment reservement. Obliged.
I'm keeping this record for some time.
Yes,
Yes, sir, lordship.
in the document he asked, my lord, after the inquiry, there is the striking.
Date is there,
point
my
here.
lord. Everything is there, black and white.
2020, your lordship will see. This is
Before,
after the inquiry.
before inquiry was submitted report.
No, before the read code for the first time, you cannot say all that.
I have given to the bank, my lord. Lordship.
5,
This will not continue.
Lordship, the matter relating whether the regarding the age of superannuation of the petitioner, who is a professor of Omya Kumar Das Institute. Lordship may take it up at 2, otherwise.
No, this court is not sitting at 2. This court will be sitting at 2, but it will be taking up different matters. There's a separate cost list. I don't know if you've seen it. Other day. Fix it somewhere there. I can't take up at 2. Because at 2, I'm taking up a different matter.
Okay, my lord. All right, man.
On a hearing date, my lord, then.
Next day, hearing date.
But P. Jagavati, then counsel for the petitioner, as well as state PC secretary, senior governor. Additional supervision.
Additional senior.
Is the matter. Again on 21.
21.
21, there'll be some different.
21 May.
We'll have it 28.
28.
28.
28. Obliged, my lord.
Lordship will keep it as part heard, my lord.
Yes, please.
Obliged.
6,
This also will have to go to another day.
On 30th, my lord. On 30th, my lord.
30.
30.
But I has cycle and council for petition as well as the stage group and CGC for the
respondents. This is a matter of very conflicting.
Seven.
I'm appearing on behalf of Mr. Pima, Your Lordship, respondent number 6.
Seven.
Yes, what do you want?
Your Lordship will wait. May the matter be fixed at Your Lordship?
I can take up it.
In that case, next week, Your Lordship.
On the first for the petition. On request made on behalf of Mr. P. Manda.
Pima, Your Lordship, respondent number 6.
Counsel for the respondent. Okay, you can vote. When do you want? 16? 16?
Sequence, Your Lordship. What of it?
8.
Lordship, this matter will be taken up any other Lordship after 1 week, Lordship.
On request made by Mr.
Yes, of Lordship, petitioner.
Is the matter after?
So the date may be given on date after 1 or 2 weeks, Lordship.
Up to 28.
Okay, last question.
9.
Lordship, my senior is in another courtroom. Matter may be taken up at 2.
I can take up it. This is different bench. I'll take up it. Who's your senior?
MJ Gaji.
Okay, on request made on behalf of MG Katil and the counsel for petitioner. List after 1 week.
Okay, Lordship.
10.
May it please your lordship. Lordship, in this case, the respondents may directed to file affidavit, lordship.
Who's appearing? Not Mr.
P. Bordley, lordship.
P. Bordley, let me counsel for the petitioner. MS, SUTL and standing counsel.
Elementary education.
Elementary education, place for
3 weeks time.
3 weeks time to file counter after place of.
Can you let me fix, lordship?
It's the matter on. Third June.
Adjournment. Oblige your lordship.
11.
Lordship, I'm appearing on behalf of P. Nayak for SCRT. Lordship, we send our affidavit for vetting. 2 weeks time may be granted.
Third MS.
MS S. Ahmed, Lordship.
MS.
S. Ahmed. Sabina Ahmed.
Yes, Ahmed. General counsel for petition. It is submitted on behalf of Mr. P. Nayak and the standing counsel.
SCRT.
SCRT. The affidavit has been sent for vetting. And placed for how much time?
2 weeks time.
2 weeks time to file this.
Lordship, a date may be fixed.
Please again on 31st.
Obliged.
Right.
Thirteen. Hearing.
I have 14, my lord. But it will not be complete before. Your lordship, I suppose your lordship is taking up some other matter at 2 o'clock.
Yes.
14, I am appearing in 14. It may be adjourned for the day.
After a week?
After 2 weeks.
Okay, on my question, like Mr. PC does.
Yeah.
Even senior counsel. List after 2 weeks. Item 14 now. 13, you right? None appears for the party, none appears for the petition. List the matter.
It like a Nicky. Obey. Yeah?
Yes.
Lordship, in regard to item number 14, a date may be fixed, Lordship. After 2 weeks, any date, Lordship, will do.
আজি কয় তারিখ 9 তারিখ 30th May or
At least on 13.
Your Lordship will just give me a moment. I'm adjusting my screen.
Okay.
Yes. Your Lordship, may I take you straight away to the review application? The review application and Your Lordship's judgment, which is at page 20, annexure 3.
Yeah.
And the beginning from page 21, 22. 21 is a recital of how the case eventually landed up in the Honorable High Court. And may I take Your Lordship to paragraph 3 at page 22.
Yes.
May I read, my Lord?
Yes.
Being aggrieved, the respondent plaintiff filed an appeal before a court of the learned Additional Deputy Commissioner Judicial, Mokokchong, which was registered as Civil Appeal number 3 of 2001. In the appeal, the respondent plaintiff also prayed for a de novo trial. So I want to pause here, Your Lordship. So a de novo trial was ordered by the learned ADC Judicial. With this as a backdrop, may I take Your Lordship to the paper book now?
Paper book.
Yes, madam.
We have a paper book. Huh? Is there a paper book?
Yes, my Lord, there is a paper book.
Oh, I didn't receive any paper book.
Oh, Your Lordship. Without that,
only the appeal is there. Just show me, show me.
There is a paper book, my Lord.
That paper book is not there. Just see in the registry if there's a paper. Just a minute.
Yes, my Lord.
Checking up. I don't think there's a paper book.
If the paper book is not there, Your Lordship, I don't think we can proceed.
Yes, let me, I'm just checking up in the registry.
Very well, my Lord.
This is my last item, so we'll go slow.
Very well, my Lord. Otherwise, my lord, if I may make so bold, there's nothing like a physical hearing.
Yes, why don't you come down?
Yes, about him. We were expecting one of your lordship's rare visits to Kohima nowadays.
No.
Whether
What have you come down?
whether it's inviting your lordship to Kohima rather than two of us coming to Guwahati and experience the Guwahati weather.
Guwahati, actually, it's unlike other years. It's much cooler this May. Very much cool.
Yes. Same here in Dimapur, actually, your lordship.
Okay.
Not very hot like last year's.
Otherwise, Lordship, the application is filed under section 114 and read with order 47 rule 1. What is wrong with the assessment? If we can confine to that, keeping in view of order 47 rule 1, I think, because it is not an appeal where we have to evaluate all the records. Lordship has called the records at the time of hearing and the order was passed.
It's a review.
Yes.
Oh, your Kohima registry, they did not send the paperwork.
Oh.
Yes, the record was also not called for, Lordship, it appears. Right now, I'm at Imbor, Lordship.
I see.
Came for an APA meeting.
Is it the APAM case or the meeting?
No, committee meeting. Our colleague Takamasa and TV Chamber board are here.
Okay.
In connection with the state meeting.
Okay. Arnold is there? Arnold?
Lordship, when we refer to the previous order, nowhere it shows that LCR has been called.
No. The paper book.
We don't find any direction for preparation of paper book also.
No. The paper book which was prepared in the earlier appeal.
Oh, the paper book in the earlier appeal. In
Yes.
the
Yes, your
earlier
lordship.
appeal. So Arnold, it's the paper book in the earlier appeal. FA.
MAF 2K of 2004.
Yes. MAF 2K of 2004.
Lordship,
Just send down that paper book.
we will try to find out, Lordship.
Okay.
Because it's not tagged with this record.
No, it may not be that. It's in that earlier MAF number 2K of 2004.
Okay, Lordship. Give us some time, Lordship.
Okay, how much time do you
I'll just try to go and find out.
now?
Yes.
Okay,
Possible or not, but I'll try.
doesn't matter. I'll wait. Meantime, we can have some stories about Impur. You are in Dimapur?
I'm in Dimapur, my lord.
Mm. So both of you are arguing from your comfort zone.
Yes.
Actually, for me, it may not be considered as my comfort zone. Tonight itself, I have to travel to Kohima.
Oh, okay. It's already 2 o'clock.
That is okay. Return journey is not a problem. It takes 4 to 5 hours.
Okay.
So that's okay. Even up to the court hours also, we can conveniently travel.
My lord, just a point. Even if they file the paper book, I don't think they can transmit it to your lordship there, Guwahati today.
They'll have to send it by a special messenger.
Yes.
Because that also can't come by mail.
Yes, sir.
Otherwise, Lordship, on 27th May, that is a Monday, I'm coming to Guwahati in connection with the Somoto PIL.
as amicus curiae. So if the matter is fixed on the next date, that is 28, my learned friend can also come to Guwahati and then I can do the case on 28.
Stay back 28th night and go back on 29th, right?
Yes.
My learned friend has got a fondness for visiting Guwahati. I don't have that same fondness, my lord.
Once you visit, then you'll get the test.
But perhaps our tastes may vary. We may not have the same taste.
That's sure. That's for sure.
No, just
Would your lordship be visiting Kohima anytime soon?
no. Maybe on 23rd, 4th, but that time Kohima bench is having holidays.
Maybe certainly.
What do I say then?
Hurt. Okay, I'll pass orders.
Very well, madam.
Hurt A, the Million Counsel for the. You're the appellant.
Review applicant.
Review applicant.
For the review applicant. As well as Mr. C.T. Jamil, Leonard Senior Counsel.
I'm assisted by Aliba Ozakam.
Aliba Ozakam.
Aliba Ozakam.
ALIBA for the respondents stuff. The registry of the Kohima Permanent Bench is directed to forthwith transmit the paper book of MF number 2K of 2004. Stop. I can't give a date then.
That's all right, ma'am. After the receipt of the records.
On receipt of the paper book, lordship can fix a date. At least
Registry is directed to list this
the
again on receipt of the paper book on a date to be directed to registry is directed to list this matter after receipt of the paper book. Then it will come, you will be informed.
Very well, madam.
lordship. Highly
Much
obliged.
obliged.